Okay, so we're going to cover a lot of this same stuff again, and hopefully about the next 20 minutes or so, and then we'll get ready for our first break. We have talked through a lot of it, but again, we're going to cover what Title IX has always said and what the new regulations say and kind of how that's going to work together. So anytime that you're starting your response to a complaint, so all the stuff Karen talked about, we understand somebody's in saddle as Title IX coordinator, as investigator currently to begin your investigative process. So step one is you have to stop any ongoing harassment, which typically means in most cases that you're going to have a discussion with the alleged harasser. You're going to start the student discipline process. You may suspend or expel that student. And as part of that is obviously a student discipline response, what's educationally appropriate, but then also being able to point to that as an action that is, one, shows we're not deliberately indifferent, but two, stops the ongoing harassment. So you've got to move quickly. You have to take steps necessary to ensure that it doesn't occur again. So even if it's an out-of-school, short-term out-of-school suspension, there are things you're putting in place, even when the student comes back, to make sure that it doesn't happen again. So dangerous words in these investigations. Some of these come straight out of experiences we've had. Some of them come straight out of lawsuits. These things aren't good. It's just teasing, no big deal. The people in our school would never do that. That doesn't happen here. I just can't believe that. Kids in our school don't send nude pictures to each other. I know he or she didn't mean anything like that. So imputing basically the intent of whatever the student said and trying to use that as a basis, either not to investigate or to avoid any consequences. You need to learn to handle these things. The workplace is difficult. In fact, I had a female teacher or a female principal say at one point, part of me wants to tell her, young lady, I'm sorry, but part of this is, I'm going to investigate, I'm going to help you out, but you need to get a little thicker skin. You shouldn't be in my office 8 to 10 times a day because something could be slightly offensive if you view it through the lens that this person's out to get you. So that sort of stuff really just doesn't have any place, especially in the Title IX side of it. If you won't file a written complaint, our hands are tied. That one in particular under the new regulations is going to go away, especially if you've got multiple occurrences involving the same alleged persecutor. When it is a he said, she said, I can't do anything, that's one of the most common ones that we hear about. It gets back a little bit to what is going to be your standard of proof, right? If you pick a preponderance of the evidence, you probably do have an opinion on which one is more trustworthy. It's all hearsay. That's one that we get all the time. I don't care is the answer from courts, if it's hearsay, if it's not hearsay. At the point that can be imputed to you as the school in terms of having actual knowledge, it doesn't matter that it's hearsay. It doesn't matter that it would be admissible in a civil court trial. It's something that can be a basis of knowledge for you. And this comes straight from some cases I think we'll talk about. Boys will be boys, kids will be kids. Everybody needs a thicker skin, that sort of stuff. These things, and the reason we put them in a standalone slide is because I don't care how awesome an investigation you did afterwards. They can show discrimination up front. In other words, if you say one of those things, if somebody hears you say that, it could taint the entire process. Okay, so during investigation, OCR requires interim measures. There are also requirements for interim measures as we talk about the new regulations, essentially the stuff that happens immediately that isn't necessarily student discipline, but is supportive measures for students. They're called in the new regs, and we'll hit on those a little bit. But again, provide the person who complained with periodic updates, minimize the burden on the parties to the complaint. So in other words, do a lot of the stuff yourself. Don't require them to interview or talk to anybody. Make sure the parties understand the process and keep them informed. Again, part of the new regulations, some of which is new, some of which is old, is making sure that you disseminate your policies and procedures on how this is going to work. So responding to harassment complaints, again, I'm not going to read down this list, but this is a good kind of step-by-step the way to think of it. I think too few people actually sketch out a plan. Oh, here she comes again. I'm just kidding. Sketch out a plan for their investigation. A lot of people say, all right, I'm just going to go grab kid number one. But I think if you put a plan together that includes who you're going to interview, the general gist of what you want to get from them, and then the documents and other things that you're going to review, that's a nice way for us to show that clearly you were not indifferent when you set out on this path, because you put some thought into how it was going to work based on what you knew at the time. Those lists will obviously expand, and I think that's good, right? That's evidence that you remained responsive to what you found out.
That's exactly what I was going to say. The existence of this somewhere, a Google Doc, a Word doc, whatever, that you keep embroidering and sort of setting out your game plan is your best exhibit in protecting you from an allegation that you were deliberately indifferent. I have no doubt that you as a school administrator can figure out how to investigate misconduct and get to the right answer, but proving that you weren't indifferent is a different step. It's like, do the investigation, but also create proof that you were thoughtful in the investigation.
Yeah, it's a little self-justification, honestly, as you work through the process. The other thing that I really like about it is, number one, you'll be able to evidence things like that you met even OCR's recommended standard. And so you should check your policy. But to the extent that your policy doesn't say exactly how this is supposed to go, following the same process every single time is actually an act of legal significance. Because in the event mom has a bunch of notes that say crazy things that she alleges you or other kids said, if you can show that, no, I interviewed those kids, even if your notes aren't as perfect as we wish they were, being able to point to a typical and standard response mechanism is a benefit when we're doing things like weighing the credibility of evidence. Okay, so for the interviews, again, I think we could do, and we've talked about doing a whole standalone presentation on just how to do the interview process in and of itself, which is, as Karen pointed out, only step one of this three-step process in the new regulations. It's one of the last steps under the current structure, but essentially, once you think through the interviews, you have to interview at least the complainant and the alleged aggressor. All possible witnesses are important because obviously that's going to go to the weight of the evidence based on your legal standard. You need to remind the parties and witnesses that they're protected from retaliation. One of the things we hear all the time is, no, I don't want to file a complaint because I don't want that teacher, I don't want that kid's parents to retaliate against my son or daughter for having filed. I just want to talk to you about it. I don't actually want to file a complaint. Number one, in the new regs, that might not always be possible, and it might not be your choice as the parent, which is one of the interesting things that we'll talk about here in a bit. But to the extent that it involves another staff member or student, you've got to ensure and take steps to make sure that it doesn't happen, that anybody who reports it or serves as a witness cannot be retaliated against in the process. That's not going to change under the new regs. And then interview strategies. These are things that, again, I think with experience, and especially if you're in a smaller district, you know those kids. You know the right way to ask Johnny the question to get the answer you want versus Joey the same question. And you are entitled to rely on that expertise. But the concept being gather as much information as you can, start general, see what they'll say, and then hone in on the specific. That's just good interview investigative technique. Yeah.
Is creating a plan when you write down the people you interview and question, is that done by the investigator or by the coordinator?
Oh, that's a good question.
It depends, right? So right now, I think it is entirely possible that your superintendent is your Title IX coordinator, but that Title IX coordinator, to the extent they're involved, has functionally deferred to the principal through the student discipline process. So when you're sketching out a plan, it should be whoever is doing the investigation, right? There's no current requirement that the Title IX coordinator be the investigator. And under the new regulations, they literally specifically say the decision maker cannot be the same person as the Title IX coordinator or the investigator. So I think that the short answer is right now, it very well could be that even if you're the principal who's not the Title IX coordinator, but you're investigating, you're the one that should sketch it out. You should probably do it in conjunction with the superintendent to the extent that person is a coordinator. But as we move forward, it's going to be whoever does the interviews, because that person, in fact, arguably shouldn't be coordinating as much with the next two people in the chain because of how they want this single investigator model to kind of fall by the wayside. Yeah, and Karen's point is a good one, which is why the counselor is a little bit tricky because that's somebody who, if they're not doing it right or if they shirk their responsibilities, now the superintendent and the principal could be the ones that have to come in and impose discipline on that person, which makes them, especially if it's in the context of a Title IX investigation, look biased. It makes it difficult maybe even to pursue the personnel case in the same way that would. So the short answer, I think, is you're the one that needs to, if you're doing the investigation now or moving forward, you're the one that should put the plan together because you're the one that helps evidence in real time, not being deliberately indifferent.
Is it better to have students write down the responses or the investigator take the notes? Does it matter?
I don't know that it matters because what we're talking about is the weight of it, the credibility. What I care much more about is you as the person who puts together the report after you're done with the investigation, being able to articulate who you trusted, why you trusted. So if you think it would be better because that kid's weaseling is going to change his story, asking Johnny to write it down, but having a conversation with Sarah, who's one of your honor roll students, who's a confidant, and taking notes, that doesn't diminish either of those things. But I think what it does, and I think the thing that you ought to think about is if you have a standard process, that's not a bad thing, but you're not legally required to have one. So I think I would say if you want things in writing, if it makes it easier for you to be able to point to as you're putting your report together, ask for it in writing. Oh, okay, sorry, I didn't know where. Okay, so now we're gonna get into some of these administrative changes that we've talked about a lot. This section that you'll see up here, 34 CFR 106.45, it is not an unmanageable read for all of you sitting out there to actually read through the new proposed regulations. In fact, I bet you could read through them, and other than stopping to pull your hair out or take a shot, you're probably going to be able to read them and know as you go through them, okay, I think I see exactly what they're talking about here, even though it makes me crazy. So if you were to read any of the stuff that they put out, this would be the one, this regulation that outlines the process. So we'll put it up on the website. But this concept that the school district bears the burden of proof, it's not either party that has to prove to you that they shouldn't be disciplined or that they were a victim. It's the school district that bears the responsibility, the two to three people in that chain of investigation under the new regulations that have to prove what actually happened. And so this concept of it seeming like a hearing or like a discipline process where to some extent, the other party bears responsibility to diminish the stuff that the other side is proving, that doesn't really apply here because it's the school district that has the obligation.
Bobby, can you start the investigation before you tell the parents so they can be part of the interview?
Can you start the investigation
Before you tell the parents?
I think the answer is yes. I mean, there's no constitutional right for a parent to be present with a student in an interview at school. I don't know if that's exactly what the question is.
And I think in large part, you're going to have to look at, you will have policies about interviewing students. Typically, it says if it's a school investigation, you don't contact the parents and you don't have to. Sometimes if you have somebody from the outside, like it's a police officer or something like that, sometimes you'll have a policy that says, yes, we will contact parents first, but typically you would not contact parents first if we're talking about a school issue.
Right. Good question. And again, we get that question all the time outside of the Title IX context too. Okay, so back to these regulations. One of the things that you'll see moving throughout is this notion from the DeVos Department of Education of preventing the accused of getting railroaded by sort of the institutional inertia that can develop in some of these cases. And so we hit on that a little bit at the beginning, but if you think about that in concept as we talk through the requirements, what you'll see is a lot of trying to make sure that the tide rises both boats together. Even as we have to do more, the reason we're doing more in some cases is to equalize the opportunity for both the accused and the victim. And so both parties have to be allowed full participation, including introduction of evidence, which obviously could be inculpatory or exculpatory evidence throughout the process. You can't restrict the ability of either party to talk, which is really interesting as you go through the investigation, because you can, for example, if it's a senior boy and a senior girl, you could put one of the interim measures they talk about is a no contact order between the two. But then the regulations come back and say, but as part of, resolving their differences, informally, if the boy can talk to the girl and they work it out or they start dating again, well, maybe that makes everything better. So that's a little bit confusing, but that's one of the things they made specifically clear in the regs is the accused and the victim technically get to talk to each other about the process itself and about their involvement in the process. You must allow the parties to have the regulations talk about others present, whether you're thinking about that as a parent, as an advocate, as an actual lawyer that is hired by the family to represent their interests. Throughout this process, I think for the most part, and we'll hit on this a little bit as we go through the examples, but they're allowed to have others present. It's really awkward when you think about a K-12 school, what it means to have others present, because if you have a kindergarten victim, it makes a lot of sense. But if you have two seniors that want to self-advocate and one hires a lawyer and one doesn't, it starts to feel a little bit different. But just understand that the regulations don't say you treat a kindergartner any differently than a high schooler, right? They're entitled to the same type of representation. Allow sufficient time to prepare for interviews, and must either allow a live hearing that's required in the post-secondary context, or at a minimum questions and follow-up in writing, and we'll talk about how that plays out specifically.
And Deb, I think this goes back to your question. You can see how this is going to be problematic. Typically, you don't have to allow parents to be present, but you can see here under the new regs, it says you must allow parties to have others present. And so this sets up a potential dilemma. So if it's a Title IX investigation, you're going to have to allow others to be present. You're going to change the rules. But if it's just your standard assault at school, your default rule may be that others are not going to be present. So that you can see why it's causing a problem, because it's setting up two potentially very different systems. So we're going to have to look at these new regs and decide how are we going to blend these together, and how are we going to make sure we're treating people equally.
And how do you separate out the interview process, the ability to present evidence in Title IX compared to the student discipline aspect of this? And we'll talk about that in a second, but you're not typically thinking about that as you work through the student discipline process, really until you get to the point where the parents might request a hearing and threaten to bring a lawyer to the hearing. So being able to weigh out, okay, this particular question actually goes to student discipline and not Title IX is going to be really, really difficult to do in real time.
Might emphasize this for the rest of the semester. You don't have to follow these.
Sure. Okay. So yeah, good question. I don't know if somebody's asked it, or if we just should have clarified it better, but these are not formal yet, right? These regulations, there have been comments that have been submitted for this school year, for the rest of this semester. All this green stuff doesn't apply. Unless to the extent we talk about that, it doesn't represent a change, right? So that's why we've done the text in black, text in green. We're pointing this out more, I think, in sort of preparation, because if we need to start firing live bullets come August, like if they put these regs into effect at the start of the 1920 school year, we want to have gone through some of this. And as you're thinking about staffing this spring, I think you're going to have to keep it in mind. So this stuff is not in place now. If that's you've been sort of freaking out and saying to your superintendent who's like, you go attend, get in here. Understand that the stuff in black we've talked about, that applies, but this new stuff isn't. We don't know exactly when it's going to be put into effect.
We have another question. Please clarify, discipline from school can be handed out before school investigation is complete. This is muddy.
This is muddy is
That means
exactly
you're
right.
getting it.
Yeah, this all sounds like bad news. Good job, you're following along. So yeah, the fact of the matter is, trying to tie this into student discipline, and I've got a slide that literally lays them out side by side here in a second, which I think will go to that specific question. But trying to figure out that what we do in discipline is we say, all right, I did enough investigation to believe that he totally groped her on the bus. I looked at the video of the bus. You can see his arms going over the seat. I believe now, based on that I've got enough to give the notice document to the superintendent, from the principal to the SU, suspend that kid pending the expulsion, and then send the expulsion letter to the family. All that stuff happens with respect to when you made the decision, which you literally cannot make until at least 22, 23 days into the Title IX process. So yes, the Student Discipline Act essentially says do enough to be able to give the parents assurance that what you believe is true and that you can prove it at a hearing, but don't do so much that you actually delay the student discipline process longer than you have to. It is triggered on when the decision maker makes the decision to institute student discipline.
And that's, you hit on one of the main comments and complaints that was submitted during the comment period, is these rules do not work for a state student discipline act. And they just don't. They don't go together. And so we are anxious to see how are they going to respond, or are they going to respond at all to that complaint, because they don't go together very cleanly.
Yeah. So yeah, if you're wondering how this works in student discipline, the short answer is we don't know. And we're hoping they're receptive to those comments that were submitted at the close of January, to at least some deference to the state disciplinary process as not impacting compliance with the regs. But who knows if we'll get it? I mean, they typically don't change regs that have been in place for 30 years, very willy-nilly. So we'll see. Okay, so this is now back to the, all right, so we're under the current law again. No matter what law applies, this step applies. Reviewing the documents and other evidence. Taking steps to preserve digital evidence. That's going to be weird under the new regulations, to put it honestly. Conferring with your IT experts on things like maintenance of that, being able to allow either side to be able to see the evidence you have. And then, like Karen said, I mean, Urban Dictionary might very well become, in a very professional way, one of the hot links on your Chrome browser or whatever it is you have, because you might be putting in a lot of stuff that you see and now deciding, well, does that constitute a Title IX type of thing, like Netflix and chill? That would be a good example. And then the step 5, prepare a written summary of the investigation and take action. This is another point where, under the current Title IX process, and what you'll be using for at least hopefully the rest of this semester, this can coincide with the student discipline stuff. In other words, we can point to that student discipline stuff and say that some of that satisfies the obligation for a written summary and taking action. If you expel somebody who's a sexual assailant, right? If somebody who's sexually assaulting people gets expelled, we can point to that. We'll write it up, right? You'll have notes on it and all that, but we might not be doing all of the things that the new regs would require. So either way, though, some sort of written summary of what you found in the investigation, the action you took, is still required.
Second bullet point is black but not green.
Okay, yeah, good. Karen brings it. Not required to provide the written report to the parties currently. There is guidance. There's sort of the sentiment in the Title IX OCR enforcement stuff that you should give the complainant all of the details and information about what it is that you discovered and the action that you took. There, in a lot of these cases, especially for a K-12 school, FERPA and other student record implications of that are kind of tricky, but there is no written in law requirement that you provide that written report, which right now is more of an internal document, a justification document, so to speak. You have to give information to the complainant, but not that document which you prepared. That's one of the things that will change pretty specifically under the new regs. So we talked about a lot of this stuff. I'm going to try to tick through it quickly as we come up on 10 o'clock here. But before you issue the investigation report, you must provide all of the evidence you have, right? So it contemplates you do this big, huge investigation, conduct interviews, and now you've got this big pot of stuff. It's some mix of your notes, written student statements, written staff statements, written witness statements, things that you found, right? Maybe it's a screenshot of a tweet or a snap or something like that, and you've got it all in this big bucket. You've got to put that in electronic format, which the parties cannot download or manipulate, and send it to both of them, and give them 10 days to respond just to the evidence without your intellectual thoughts of what it might mean. They just get to, I think, help you decide credibility. Must allow the parties to respond prior to issuing a report, which means you really shouldn't start your report until day 11, or you probably have some sort of risk in there that it looks like you would predetermine without getting their responses what was credible. So then after that, after the 10 days, so let's assume we're on day 11 now, you've got to issue your written report where you have to summarize the evidence that you believe to be important. And that report then must be issued 10 days before the decision is made, with the opportunity for both parties to respond yet again. Question.
How do we preserve digital evidence if it's illegal to view it?
How do we preserve digital evidence if it's illegal to view it? So in other words, student walks in and says, my significant other sent me this nude picture. You know that your first response, number one, is going to be to call the police, right? I don't care what the new regulations say. We don't want the sort of situation that's developed in these cases like from Virginia and others where administrators have been prosecuted for possession. So we're just going to tell OCR that I don't care if somebody actually gave us that and this bundle of evidence would otherwise include a nude photo of a minor. That's not something we're going to include and put in there. Now, there might be a note or a document evidencing, hey, this is what I was presented. This is what it showed to me. But I don't think we're not going to start trading in. The craziness of this is not going to make us start trading in child pornography. We are not going to allow that to happen because there's too much at stake for the administrators as that are investigating. Okay, so these two things have to happen, right? So if you're thinking to yourself, that's at least 22 days into this process, you're exactly right. Then on day, what would it be, 21 or 22, is when I think you can issue the written decision. So I don't think most K-12 schools are going to hold an actual hearing, but you do have to allow question and answers back and forth. We're not exactly sure how that's going to extend the timeline for a decision, but at some point after all this stuff happens, that new decision maker is going to have to deduce to writing the decision that they've made. It must be issued to both parties simultaneously, which is different again than Karen pointed out. Right now, you don't have to do that. You might have to inform them of the decision, but not give all the underlying documentation and report. And that must include identification of the code of conduct section allegedly violated, description of the investigatory process, findings of facts. So where do we make credibility determinations as the decision maker? Conclusions of application of the policy to the facts, or the law to the facts, as I think we view it. The rationale for any sanctions or remedies, like I think if I do this, he'll quit the misconduct, which is one of your obligations, and any appeal process that's allowed, which makes it complicated again, because our Student Discipline Act contains an automatic appeal process, but you don't necessarily have to have an appeal process under the new Title IX regulation.
If you're saying to yourself, holy cow, this sounds like two legal documents, two legal briefs, the investigation and then the decision, sounds like lawyers wrote this and lawyers are expected to write it. I think you're right. And that's why we're still, like I say, we're exploring ways to get you the help you need, but it's going to be way more lawyerly than the student discipline stuff that you've got now.
Yeah, and it's when they put out new proposed regulations, they're required to include essentially what do we think the financial impact of this will be.
Yeah.
And they estimate for each new Title IX case, something like several dozen attorney hours, even if that attorney is just assisting the school in complying. So the federal government is literally saying, by putting out these regs, we concede that all of you are going to have to call somebody like Karen, Steve, Bobby, Cody, Mandy, or your school's lawyer to help you with this process for dozens of hours at a time, right? They're actually contemplating that very thing. Okay, this I put up here, and I think this is the last slide that I've got in my part of this presentation. We'll take a quick break. But again, this just lays out some of the concepts in terms of lining up side by side the Student Discipline Act and some of its general timelines with these new Title IX regulations. It goes to the several questions we've gotten about how do you possibly reconcile these. I don't know that you can. So we talked about the day the decision is made, which is in most cases the day of the incident if it's something like a sexual assault. The principal has to send a letter to the superintendent. That's the one that allows you to kick to say that the student needs to be suspended immediately. Within 2 school days then, you have to give the letter as the principal to the family. They get the 5 days to request a hearing. Once the hearing officer is appointed, within 2 school days of being appointed, they have to schedule it. And then the hearing has to be held within 5 school days of the request. The hearing officer, after the student discipline hearing, reports back to the superintendent, who's required to issue a decision to the family, who then has 7 more days to appeal to the board. It is possible, I think, under the student discipline law, that even if everybody takes the maximum amount of time for each step of the process, that within 25 days, possibly as few as 22, you could be done with the entirety of the student discipline process prior to getting that baby into actual court if the family wants to appeal again. Compare that to the Title IX regulation stuff that we just talked about on the right side. That says the day of the incident, you begin the investigation, right? You got to give them, even if you gather all the evidence on day 1, you got to give them 10 days to respond. The investigator has to write a report, which we assume is going to take at least a day, give that to the families who then have 10 days to respond to that. And at some point in there, I should have added, there's this concept of question and answer back and forth between both parties with the investigator and to each other, which Karen will talk about later, I think. And then there's some written decision by the decision maker who may be the superintendent. So you're talking about the Student Discipline Act potentially ending prior to the first really decision on what consequences are going to be implemented under the new regulation. So again, those aren't in effect yet. The Student Discipline Act obviously is, the Title IX stuff is. But again, this is more to affirm your frustration that I don't know how this stuff's going to line up. Anything for you two to add there? Okay, that's a new slide. So we'll post it if you want to bring this as evidence to the superintendent that you're not crazy. I promise this is what they all said. So after the investigation, Karen hit on this. We're just going to not touch on it any more than to say there could be school-wide responses. This concept of we have this culture in our activity program of allowing hazing, bullying, goosing, credit carding, that sort of harassment. And it talks about things like making sure that you train staff, students, and parents on recognizing, reporting, and responding to these things to not have these sorts of instances occur. Follow up with the victim. Karen mentioned this. We'll talk more when we get into the sort of the victim response stuff you have to have throughout this process now, these interim measures before the crazy new system actually gets all the way through working. That could be things like making sure that you're referring students to the SAT team as necessary and anything else you think educationally appropriate. You also have follow-up obligations with the aggressor. That's current. I mean, that is in place now. This notion that we're going to expel that kid and then that's the end of it isn't true under the Student Discipline Act. There's some interim education that happens, but Title IX would require you to ask what that student might need to stop the aggressive behavior. And that's it.